Hello everybody, you have tuned in to Eric Jose on Making a Murderer on YouTube. I cover virtually any aspect of making a murderer. I go over the evidence, the documents, the photos. So if you like, stay tuned, and in the future I'll have many more videos besides the one you're about to see. Okay, hey, how you doing, folks? We're back here today with part 2 of the state of Illinois versus Jesus Sanchez. You guys, I posted a video yesterday. Now, I realize that video was a bit pedestrian. It was a bit, it's just, a lot of documents and stuff there. But the reason why I did that video, folks, is because I wanted to go ahead and try and give you guys some of the backstory that goes along with this. So that when we get into this video, where we start getting into the specific things that these 3 appellate judges were pointing out that they felt were severe issues in this case, are seams that run right through Stephen and Brendan's cases, and it's kind of interesting. So that's what we're going to go through today now, is the more specific things. Less documents today, more talking about kind of the significance of some of the events that happened, and especially because those events parallel certain things that happened with Stephen and Brendan. So that's what's going to make this one interesting today, folks. So we're going to, obviously, we'll move right into it. We're going to be going on to some very interesting things that happened in this trial. There's number one with the interrogation. The suspect resisted them for 12 hours and was begging literally for his mother. I mean, you're going to see here the extent that this kid, this 18-year-old kid, went to push the point that he wanted to talk to his mother. She had just had surgery. She didn't know where he was. And he'd been at the police station for 12 hours. She had no idea where he is. And he's like, I need to call her. At least let me talk to her real quick, because she's in the hospital. So a lot of interesting things. We have a judge that basically was just outwardly, not even hiding it, biased against the defense. I mean, he basically kneecapped the defense in this case. And what that means, when you kneecap somebody, it means you basically send their knee against the way that it's supposed to bend so that they can no longer walk. So yeah, that's what the judge was essentially doing in this case to the defense. And it's shocking to me, really, when I read this, the way this judge acted. It's amazing. And he acted that way, and it turned out that the defense would have, if he had done it right, if the judge had addressed the situation properly and waited for the rehab center to get the information together and send it to the court, then the defense would have had something very, very significant to help her client. It's an amazing case. These 3 judges, these 3 appellate judges in Illinois, really, I think, deserve a big hand here, because this case has obviously got the possibility of going to the Supreme Court. And if the Supreme Court hears it, it'll be interesting. And not the Supreme Court of the United States. Sorry, not the United States, not SCOTUS Supreme Court, but Illinois State Supreme Court. If their state Supreme Court hears it, they could overturn what the appellate court said. But the appellate court is sending a message here, and I think it's worth talking about. I think it's very interesting, and I think everybody should know about it. So we'll get into it now. Robert Burke, a trace evidence analyst, testified that when a person fires a gun, the gun emits smoke containing lead, barium, and antimony, and particles of those elements usually fall in the hands and clothes of the shooter. He tested Sanchez's clothes and the swabs taken of Sanchez's hands. He found no trace of any of the 3 elements on the clothes and no trace of any of the 3 elements on the swabs. He explained that the test could show a negative result even though the subject fired a gun if the particles were either removed by activity, not detected, or not deposited. Not deposited? It's my understanding that it's impossible for it not to leave residue. And that's why that's such a highly used forensic technique. But, okay, moving on. He said, normal hand activity is going to remove the residue over time. Well, we already know it didn't have much time, right? Because 30 minutes after the shooting, they were handcuffing him and putting him in a cop car. So, okay. He said, one would lose some he also found none of the 3 elements on the hand swabs and the clothes of Estrada or Flores. So they literally found no gunshot residue on any of these guys' hands or clothing on any of the three of these guys that they were questioning. So the thing that I think is interesting there is him suggesting that it could have been removed, but or not detected. You know, I mean, it's just like, are you kidding me? This is a tried and true test. You know, I mean, any lab, you know, analyst at this point, you know, who's been working at a crime lab for a while knows how to do this test in their sleep. So, I mean, and it's very relied on. So we know that it's a good test, that it's usually reliable. Otherwise, it wouldn't be relied on so heavily. You know. So anyway, okay. So you hear that? That's the expert for the prosecution who basically tells you they didn't find any of the gunshot residue (GSR) on Mr. Sanchez's hands or his clothing. Okay. I have never ever heard before what this guy was talking about, that it was possible that it wasn't detected or that it wasn't deposited. I never ever have I ever heard that. I've always heard that if you fire a gun, that for at least 3 to 4 days, I think it's at least 3 to 4 days, that you are going to have that residue on you that could be detected. That's what I've always heard. So this guy's claim that it could have been, you know, not been deposited or not detected just seems laughable to me and completely ridiculous. And obviously it could be why the appeals court decided to, you know, reference his testimony in this opinion that they gave. Because, yeah, that strikes me as odd. But it also tells us that he did not have gunshot residue on his hands. So what the heck was going on with that presumptive test that they did on him that night right there in the police station? What was going on with that test? Why did that come back positive? You know, what caused that? And you kind of see that the appellate judges do actually address that fact a little further on here. So, but right now we're going to move into Mr. Flores, one of the friends of Mr. Sanchez who was with him that night, and his account of the way that the interrogation went. Now, Mr. Flores, people, he's the guy who was with Jesus and the other guy, I forget, I think it's Miguel or somebody. Anyway, he's with these two guys, and they split up, and then that's when like all this stuff starts to happen, right? That was the story anyway, and the story just didn't wash because it didn't fit the known facts of the case. But anyways, Mr. Flores is basically somebody who was there. So Mr. Flores was actually a witness. He was, you know, present for most of the stuff that happened this night, as were many other people. And the police interrogated all these people, and the same story came out. Yet these officers forced their own narrative, forced their own version of events, and would not accept when these people were telling the truth, particularly with Jesus Sanchez, would not accept his truthful recounting of the story. They basically fact-fed him, told him what they knew happened and everything, and then told him he wouldn't be able to talk to his mom until he was honest with them. Oh, there's that being honest, telling the truth after some fact-feeding. Yeah, I mean, this case is very similar to Brendan's, and this kid, even though he was 18, he's not a kid really, but this kid is 18 years old, and this in the Illinois Appellate Court is really just giving the handling of this a pounding. They're just basically going, this is an absolute ridiculous travesty here, you know. And I agree, because when you ignore the consistent stories, the stories that you're getting from multiple witnesses that aren't changing, and then you hear those same stories from the people that you're actually thinking might have been involved, and whether you're right or wrong, you are trying to pin the crime on those particular individuals. And then with those individuals, you hear that same story from them, but then you just start telling them that it's bullshit and stuff like that, and then start feeding them the facts of what you think happened until they acquiesce to give you what you want from them. So that's pretty crappy. That's the way this went. And, you know, that's why this appellate court is stepping in, I think, because, you know, they're looking at this situation just going, oh, my Lord, this is an absolute mess. And they're right, it is. And there's other similarities here that are going to parallel Stephen and Brendan's case. We're still kind of in the first couple of, you know, screen captures here from the decision. So let's move into the next one with Flores giving his account of what happened during the interrogation. Flores testified that in the statement video recorded at the police station, he lied to police about the shooting. He explained that the police threatened to charge him with murder. He told police whatever they wanted to hear so that he could avoid the charges. He agreed to whatever Detective Bischke suggested. Actually, he had never seen Sanchez with a revolver. Flores explained that he believed Bischke when Bischke told him that Sanchez had already confessed and Sanchez felt bad for shooting Orozco. Flores believed it would be okay to say that Sanchez was the shooter then. He told Bischke he threw the gun in the pond because otherwise they were going to keep him in there. The prosecutor asked what evidence the officers said they had against Sanchez. The judge overruled the defense's objection, finding that she had brought it out. Flores said that the police told him that they supposedly found powder or something like that, guns powder, on Sanchez's hands. Okay, so there we see Flores basically admitting that these cops completely intimidated me. I just wanted to tell them what they wanted to hear so I could get out of there. You know, and they said that, you know, Jesus confessed to it and that he felt bad, so I figured it was okay to say that he was the shooter so I could get out of there because I could tell they weren't listening to the truth. Right? And we know that they were ignoring the truthful story that was coming from many people. Okay, so and when we get to later on when the prosecutor in this case does just like Ken Kratz at Stephen's trial and starts almost like trying to shame the jury into if they could even possibly have any kind of notion that law enforcement did something wrong, then that's a travesty, and you know, it's like kind of one of those like Ken Kratz did. I mean, you'll see here, it's amazing. But so here we go. We're gonna be moving in now. We moved on from the fact that Flores, you know, testifies that he was just completely intimidated and overwhelmed by the officers. So now we're gonna move into where the judges talk about what the strange things that happened with the jury and then in the presence of the jury. And one of those things that was very, very interesting that I thought was they played excerpts from Mr. Flores and Mr. Sanchez's interrogations. They played a bunch of excerpts from them, but only the ones that really worked for the prosecution. Only ones that supported the prosecution's case that they were, you know, trying to put forth here. When the defense asked that one of the pieces at the end of Mr. Sanchez's interrogations be played, where he's, you know, basically asking for his mom, and that he basically told them all that because he wanted to talk to his mom, and why can't he talk to his mom or whatever. She wanted that to be played for the jury as well, and this judge said nope. Basically just denied it. That's what I mean when I say that this judge was kneecapping the defense. That's what he was doing. He was hobbling them. He was making it very difficult for the defense to really present the case and to really show the jury that these cops were having severe tunnel vision. And don't believe any of that cone whatever crap that Fassbender talks about. That's bull. It's tunnel vision. They tunneled in on these kids instead of this bone crusher from the Serenos, who all of these kids were all saying was the one that did it, and all of them were saying that Sanchez did not have a gun that night. And I don't know what happened with their presumptive test, people. I don't know if that was just some BS that they conjured up. I don't even know what it is. So it sounds, even the appellate judges are saying it sounds like this is a relatively new form of test or whatever. So, you know, you'll see what they say about it later on. But I mean, this test is kind of strange because it came back positive and kind of fueled the police to do what they did here, instead of focusing on the party that everybody was saying was responsible. Now, if you don't believe these kids and you think they're lying to you to cover for their friend Jesus, that's fine. I get that. Law enforcement, totally get it. Okay? What I don't get is why you didn't at least go look into it. Why you didn't at least go try to find this bone crusher, find something out about him, see what kind of things he gets up to, see if it's kind of his MO to do this sort of thing. I mean, just check it out. Right? Because something tells me had you checked this out, you would have found out that Bone Crusher did fit all the every accounts that you were getting. And you're going to probably find out that he was up to some pretty bad stuff. He probably might be one of the worst guys over there in the Serenos. You know? He might be the guy that's down for whatever. You know? So, hey. I just don't feel that these cops were interested in looking into what really happened. I just think that they maybe had... Most likely what happened here is that they had been coming out there and dealing with some knucklehead stuff that these kids, Jesus and Miguel and Flores and all of his little friends, that they were probably having to come out and deal with some knucklehead stuff that these guys were doing kind of on a regular basis. So when this all happened, these cops might have just been like, you know what, I'm sick of coming out here. Let's pin this all on them. May not have been like something that they said out loud, but any cop that was tired of coming out there might have just been willing to go along with the lead cop who said, okay, look, these guys, we're going to take these guys in for questioning, blah, 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 blah. All the other cops just fall in line. All compasses point north. Right? So, and that's what happened with the judge. The judge's compass pointing, north. Way north. I mean, that guy, anyways, you're going to see right here, because you're going to see some of the things that he said in front of the jury and further proof of how he was basically kneecapping the defense. So we'll move into that right now. Defense counsel argued that detectives fed an account to Flores and Sanchez and pressured them into assenting to that account. The detectives used lies about the evidence and emphasis on words like accident and mistake to minimize it. Remember, from what we've all learned from the amicus briefs for Brendan, minimizing the crime, lulling the suspect. So, to induce the acceptance of the false accounts. In the prosecution's rebuttal, the jury heard the following. Prosecutor, it's bad enough to insult the integrity of the law enforcement people that were involved in this case. It's bad enough to put dishonor upon their reputations. The people that are out there saving our lives and our communities. Sound familiar, people? Does that sound like anything we remember from Stephen's trial? Now, when you know what we know from this, what the appellate judges are telling us after reviewing this, is that all accounts said that Sanchez did not have a gun and that Bone Crusher is the guy that they wanted. That's what everybody was saying. That is the consistent story. Remember how I've always talked about that with Brendan? The story that he told consistently was the one where he came home, played video games, That was the consistent story. So that is the most likely true one. And so for me, it's laughable to sit here listening to this prosecutor right now talking all indignantly that law enforcement's getting called into question at all here. Are you kidding me? I mean, seriously, they were ignoring the obvious. This prosecutor is a piece of work, in my opinion. But the judge is even better, because the defense says, objection, judge, and the court says, overruled. So this is a little later on in the prosecutor's closing argument, I believe. I've never seen anybody murdered by a cupcake before. He wants his mommy. He is nothing but a sniveling, cowardly killer. That's what he is. What were you doing out there all day, Jesus? Like, I guess he actually turned and addressed Jesus in the courtroom there. So or at least that's what it would appear. I'm only looking at transcripts, obviously, but obviously this was a problem for the appellate judges. The defense counsel says, objection, judge, and the court says, overruled. Right. Okay. So we move on. Prosecutor. Talking about Flores knew, because when he was asked, why were you being chased? What did he say? We were being chased by the Serenos because they thought we had shot someone. And that's why And that's why they were being chased. So that's what he's saying, right? Miss Kohler, objection, Judge. The court, what's your objection? Miss Kohler, it was the subject of a motion. And the court says overruled. So that means that there was a previous agreement not to talk about something that the prosecutor just brought up, and it was previously agreed, and the court just basically decided that was no longer in play, just like it decided a few other things in favor of the prosecution. And now here you see this, the defense is trying to stick up for their client, but the judge is totally making it impossible there with these objections, with these overruling the objections. So anyways, after the jury began deliberating, Sanchez moved for a mistrial based on several evidentiary errors and pervasive judicial bias against defense counsel. The judge denied the motion. The jurors deliberated for 5 hours before sending a note saying, "We are split." The judge ordered them to continue deliberating. 5 hours later, the jury returned a verdict finding Sanchez guilty of murder of Orozco, but not guilty of attempted murder on Edson. Sound like something else we know from the Stephen Avery trial, folks? Remember how they found him guilty of murder, but not guilty of mutilation of a corpse? Interesting. So I honestly, also one more thing about that. I can't help but wonder what kind of pressure was exerted on the jury in that second 5 hours. Than that, after they sent the note saying they were split, basically, I wonder what kind of pressures might have been exerted on the jury. Subtly, I'm sure, but somehow I'm sure there might have been some kind of suggestion made or something that the jury decided to do what they did there. But like I say, it's to me striking how very similar that is to what happened with Stephen Avery, and when the jury came back with the verdicts on Stephen Avery. Like there was bargaining going on in the jury room, and basically the bargain came down to the people that wanted to vote that Sanchez was guilty made the agreement, well, if you guys vote with us on the murder, then we'll go ahead and vote with you not guilty on the attempted murder, right? So that's basically kind of, you can tell that that's kind of the deal that went down here, and that's a no-no. It shouldn't happen. So anyway, all right, so you see that horse pucky by the judge there? I mean, I don't think a prosecutor is allowed to address a defendant directly in court unless he's actually on the witness stand. That's the way I've always understood that, but obviously I'm going to be asking some lawyer friends of mine about it. But yeah, I mean, is he allowed to do that? I mean, I think that's probably why we got an objection from the defense, but this judge was just denying everything from the defense. Just overruled. And I think it's pretty obvious. And obviously, with these particular examples that the appellate court pointed out, they felt that the judge was out of line. Otherwise, they probably wouldn't have added them in, right? So, not just my opinion. So, that's interesting. Obviously, you see that kind of bias in the courtroom from a judge. And I think we see it kind of with Judge Willis, too, like not seeing the significance of voicemails being deleted when the defense is putting forward a theory of defense that somebody was tampering with the evidence in this case, and the voicemails are evidence in the case. And that evidence was tampered with on 11/1, on November 1st. So the fact that that happens at a time when Stephen can't have her phone in order to do it himself, somebody's tampering with the evidence. That's the whole theory of what the defense was trying to say, is that there was somebody tampering with evidence, and it was a planting defense, right? All that, right? So the fact that Judge Willis doesn't see the significance in those voicemails, I mean, that's just one example of how biased that Judge Willis obviously was. He allows Kratz to just not have to explain why they don't know who deleted those voicemails. He gives Kratz a get out of jail free card. Essentially, he just doesn't push it any further and just says, "Oh, I guess I don't see the relevance." Well, think about what kind of a defense the defense is running, Judge, about tampering with evidence and these sort of things. You don't see the relevance in deleted voicemails, huh? Yeah, you are biased, my friend. So, another little similarity that runs between this case and Stephen and Brendan. All right, so this is gonna be it for part 1, folks. Just so that these things don't get too long and you can break them up and view them over maybe a few days. I realize it's a lot of information, and it's always this way with a new case. It's hard for me to try and sit here and explain to you what the judges are saying if I number one don't look in and try to comprehend and grasp the sequence of events. It's hard for me to try to explain to you. So the reason why there's so much material here is because I'm trying to bring us all kind of up to speed on the case, while at the same time pointing out the wonky things in it, as the appellate court is doing here. So I think this is interesting, though. I think this type of thing is, you know, kind of what needs to happen, because this is going to get the community of judges looking at what the Illinois appellate court did here, and they're going to start thinking, you know, do we need to maybe do something like this in our state? Do we need to start, you know, putting our foot down and trying to, you know, get the police and everybody to use more, you know, proper practices, particularly with young people, juveniles, and, you know, even 18's right on the cusp there. So, I mean, you know, these people have not fully, you know, created their own adult identity yet. They're just more susceptible to those tactics. So, but that's where we're at with this case. And I just really think that the appellate court is trying to send a message, and we'll actually see how much it catches on. If it catches on like wildfire, and we start seeing other state appellate courts, you know, issue similar judgments in reference to, you know, custodial interrogations of youth and tactics used on the youth, and whether or not, you know, the full read technique is not supposed to be used on juveniles. You know, the full-on read technique is not supposed to be used in its full, you know, full strength on juveniles. It's been proven, and almost, I mean, and a great percentage of the law enforcement community itself agrees that using the full-on read technique on juveniles and young people and people of limited intelligence, or that have some mental disability, that it absolutely creates false confessions often. So anyway, that's about it for part 2. You know, obviously part 3 is gonna also be coming out, so you guys can move on to that. I'll leave the links to jump from the videos, you know, so you can just go down to the link, the info box below this video, and you can click the link for part 3 to go right to it if you want. So anyway, that's about it for today. If you haven't already, please hit subscribe, and we'll see you.